Secondly, good afternoon. Land people, good afternoon.
Good afternoon, sir.
Do we have one from New Zealand today? I think she's absent today, right? But this is a very nice article. I will upload it to the LMS, right? So there in this article, it's about the legal personality of the company. The article is in New Zealand. They I'm not sure whether it's given. Right? So they were planning to give a legal status for a river. So this article is about that. So that's why I said that we have New Zealand today. So they have given that task. Check whether it is done and let us do a brief by next class. So other than that, the New Zealand tried to give a legal status for a river as a corporation. So you know, New Zealand has a very update law related to the corporation. I think these things are there in Japan as well. If we have seen Japanese, they have a Kujya, right? You all heard about Kujya, I don't, right? Even when you were there, or not, you know what is Kujya, right? So, do you know how do Japanese people address their all the Kujya? Yamaka name, which is Hangaki, Fuji, right? Japanese call it Fuji-san. Japanese call Fujiyama Fuji-san. They will Fuji Yama Fuji-san, Fuji-san. So I hope his friend, they had given that status to the Fuji-san. It's by the people, not by the state and perspective. But Japanese people believe that type of heritage site as a person. You know, any Japanese people just ask how do they call the Fuji? They call the Fuji-san. So they use the term san to be the person. Japanese, the people has given that status, right? In New Zealand, government going to give a legal status for a river. It's a property. That concept of property was converted or transferred to a legal person. Probably they are in trust or whatever next instead of the board of directors, so they will trust. The river itself become a person, so it can protect itself. So those are new development of corporate law. Even the Sea of Srilanka, you could make a legal person. If something happened like what happened in the ridiculous position or whatever, it's just can protect the person. Right. So I will upload this target to your LMS. So, if you are in contact with the New Zealand candidate students, just ask whether it is already done and what is the new status of that comparison. One don't know if you are right or not how to pronounce it. That's a big name of the village name. Right, Lama, when you have free time, you read these articles, so I will element, right? You use a month of legal person, right? Just read the legal status for the company of operators. You have either sites, right? Network sites, right? So, the first time in the world, I think, that you are going to be a person and a legal person. You will upload it to your site. Right? So, I have planned to have quiz today. So, anyway, you are lucky, so probably we'll have next week because I have sent it the subject school, but they were busy last week. So they said that they did not a week to upload it. So therefore, they will be this. They promised me that they will upload it within this week. So then the next week we can have the right, so probably this will get to the incorporation number, type of number. That's good. Yeah, 15 right. So we can start another topic today. I was thinking for the next breath to have a quiz in the weekend lesson. So that we do a continuous assessment as well. So for the next one for you, right? For the next lecture. Right. Yes, today we discuss about the capital shares and dividends. Capital shares and dividends. So just what coming. So these are some topics that we're going to discuss. Capital shares and dividends. Then allotment of share, then distribution, right? So we're going to discuss some of the important concepts of concern for the accounting management system, including the distribution and program test, and also how to maintain the custody and importance of structural maintenance. Those are the subtopics that we're going to discuss under this topic. So we will start with capital. Probably very common term for you people. Then we lawyers. And probably use every day more than one time, right? Almost all the time. So just give me what is capital. how do you define what's the meaning of capital? What's the capital mean? Man-made aid, man-made aid for use the okay. I don't think that the act has a meaning for the capital common meaning, but act define the state. So if it is state of capital review, so it defines the state of capital, maybe 56. Section 56, I can define the state of capital. So before that, you just look for the general meaning of the capital. You can just interview the meaning of capital or dictionary meaning of capital. And check whether that complies with what you thought. Is it complying with your meaning or is it different? So if you want some student can get the legal meaning. So you can also check the accounting or auditing meaning, right? Is it said that what you mean or almost there? You can also check the legal meaning. What does it say? Is it confusing or
Basic.
basic? Yes.
Is the rate of partnership an individual, including actual funds, equipment, and property as distinguished from stock in trade.
More detail. Next. So, some meaning for the term capital. So, capital is the wealth or invested by a person or an organization. So, you all know that capital consists of a equity and debentures, share capital and the lower capital. Shares and debentures. So, I also have given you the auxiliary meaning of the term capital, right? So, for the auxiliary meaning, capital means the money or other assets with which a company starts a business. So this is the legal meaning of the term capital. In fact, it's not the legal meaning. Yes. A judge in one case, in this case, tried to define the term capital in this way. You just say So first he says, like many other legal terms, capital is another legal term which has no special certain technical meaning. So we can see throughout our law subject, like even from the very first year, first topic, contract law, right? You have some issues about agreement or contract, right? You have some issues about the term offer, right? What is meant by offer? What the plain public feeling is completely different than contract. When you start the consideration, it is that's a very confusing, complex meaning. Right? So even the contract law, even the law, term law itself has no clear meaning. So when you start the contract law, you will see even the term company has no certain technical meaning. So you can use the term company even to mean the part. But we people use the term company to mean the limited liability company. So that's to some extent that's the nature of law, right? So we also learn in next week or week after, even the term direct. There's no clear meaning. So this is, even though this is maybe a term you use in management, accounting, or things like that, but still, it's also such a term which has no technical meaning. Right? So, to the economics, it is something else. We explain it. He said to the economic, it usually signifies tangible instrument of production. Right? That is a typical asset used in the creation of other purpose. For an average man, frequently think of money as capital and uses the term as saving. So the bankers, it is something else. Right? So bankers often use the word capital in the sense of net worth. So we have some bankers, so that is their meaning or understanding of the term capital. Right? So, however, in business or law, it's a very confusing term again. Right? So, business people believe it is investment in an enterprise, as you all said. That's what probably you also mean, right? So, but for the legal term, may be thought as of being represented by money or money's worth. Being represented by money or money's worth. Consisting of property and other valuable tangible assets. Consisting of property and other valuable tangible assets, the body of property is paid. This. So, therefore, sometimes you use these terms, right? So they are meaning maybe slightly different according to the nature of your business or to whom with you deal. When you deal with the general purpose, so it's different thing. They generally use it as a money. Right? When you deal with the bankers, they use it as a net asset. Right? With the accountant auditors, maybe different meaning. So likewise, with the person you dealing with, the meaning of the definition may be slightly different. Right? But the law definitely has given a wide meaning again for the term capital. Right? So you are again lucky because you all learned 2007 campaigns. Right? Before 2007, there were different types. You are lucky not to learn. After 2012, now there's only one type of capital called stated capital. Before that, there's nothing called stated capital. There was a capital. It is purely several capital. Right? There's something called authorized capital. That is the number of shares the companies can issue according to the memorandum and articles of that. So directors could not issue more than. Therefore, deputy director restriction not take this part. Out of those authorized capital, the number of shares they have issued were known as the issued capital. Then also, even though they have issued 10,000, sometimes all are not subscribed. So whatever the subscribed and error were known as the subscribed capital. Like that, there are different types of BD policy capital for 2007. But now there's only one type of BD known as the stated capital, and it is very clearly defined by section 58. So section 58 one says stated capital means the total of all amount received by the company or due and payable to the company in respect of issue of shares and in respect of all on shares. Basically, talking for BSAA, so almost all the shares are fully paid. But law is set out on call on shares sometimes. In fact, long time ago, as companies were not that much popular, the shares were issued to pay them. Then those issuers or shareholders were liable to pay on call. That is why we still use the pay on call, but still there may be some shares they were not fully paid. Or maybe some initial shareholders they were not fully paid. Then they are payable, right? So they are payable and they are liable to pay on call. So according to stated capital means the total amount paid plus the total amount remaining to be paid in terms of issue of shares and in respect of foreign shares. So stated capital represents the total value or asset received or receivable by the company. For the debentures, we will just discuss about the share and then we will come to the debenture, right? So because capital consists of both shares and debentures, so we just discuss about the share and then we will discuss about the debenture. Can you also you will try to define a share? So the US factors defined in the capital. So what is a share? Ownership of the company, okay. Part of the equity portion. No, part of the equity portion is okay. Part of the equity portion of the equity portion of the company. When I was in a law practice about 25 years ago, right? This is a subject that I hate, especially because of those type of time. But capital share, that's fine. So one of the subjects that I was not happy and comfortable with, right? And that is my fate, really I had to teach. But it was a part of our life. You have a command, but now who gonna run it, Mako gonna recommend the event gonna get that. So I thought I'm so lucky at least. Not like that, you know. I'm gonna be getting another grand. At the gate, but that's the man feel like I think that's it. But I'm going to get into that. Right. Financial or corporate or basically, especially for company. The those things are not very company. And also it was an option at that time. Still I hope it's option. But in low college it is possible. Low college you could have to get the but for the degree it is option. Right. So just yes, if I start with your child, I can say share may be a smallest part of the time. I think that is something about we're going to find. So if the smallest part of the capital can be called as a share. According to the companies act, it says under section 49, share shall be a movable property owned by the company. Share is considered for the company as a movable property owned by a company. For the property also, there are some different surface being in law. That is under the properties regulated by the Roman Dutch law in Sri Lanka. For the Roman Dutch law, property has a different meaning. So share is not with that meaning according to Roman Dutch. Roman Dutch law property here as to the main Roman Dutch law is action. It is a type of right or property that you can enforce through court. So they are known as chosen action. So they are more than the property, they are rights, which you can enforce through court. That's a type of property. But they are not moved according to Roman Dutch. What can chosen action here? You can enforce through court or through litigation. Different type of property. But luckily, this is not the consent law is governed by the consent law principle. So English law principle. So for the English law or consent law, share is considered as a movable property owned by a company. And it is also the smallest part of the capital. So that is also one case where they have tried to just define a share, right? In that case, again, the judges, that is widely accepted for the meaning of share. Right? So in that case, they were trying to explain the share as it is the interest of a shareholder in the company is called a share. Right? And interest of a shareholder in the company is called a share. With that interest, they have some unfettered rights. Those rights include as main rights, right to vote, right to dividend is declared, right to surplus assets, and the event of ID. So those it is a share, right? It is the interest of the shareholder in the company is called a share. That interest include right to vote, right to dividend, and right to surplus assets. And there are of course some other rights that they can effectively enforce. That is what the judges define as share. It's the interest of the shareholder in the company is called a share. That interest includes those type of rights that they can enforce through court. So you all know shares can be freely transferred, right? However, there may be some type of restriction for what type of company. For the private company, there might be a restriction, but it is not provided by the model law. Before 2007, there were restrictions on transferring shares of private companies, but now that restriction is no more included in the 2007 Act. However, if they want, they can have such restriction. But for the public companies, there should be a free transfer of shares. Such restriction should not be there in a public company. That is a requirement of the CST rules and regulations. Therefore, you can't have such restriction for the PNC. But private company, if shareholders want, they can. So it's a movable property, can be transferred in the manner provided by the articles, but should be freely transferred if it's a PNC. And also, this act says that or accepted that companies can issue different type of shares. Even before 2007, they did, but it was not accepted or recognized by the law. But as a practice, they accepted and it did. But now it's clearly says companies can do different type of shares. And in particular, it says the companies can issue shares, renewable shares, preferred shares, and shares which are without limited voting. So income tax issue, those type of share with the rights and liabilities of the company itself, that is fine. But if the company issue share with more rights or liabilities, then when there is such a issue, they have to issue a term of issue as well. They issue rights which is not provided for more than the companies accepted, then with the term of issue, they have to clearly mention those rights and obligations, liabilities, and so on. So that term of issue become a part of articles. Right? You know, article is a contract between company and shareholder. So whenever you issue shares, you have to issue term. You have to also issue term of issue. That term of issue also become a part of the article. Yes, another important thing is now there's nothing called par value or nominal value. We are really lucky today. Now there's nothing called those type of par value and so on and so on. Now there's only called one called that's a fact for market. There are some issues about the market value. That's at least there is some market value. What's the market value? Let's try that first. According to the portion they will take. Right? So that's the market. No, that's the true market value of the Sri Lanka. Therefore, whatever the law says, there are issues. So I know it, I'm a lawyer. I do that. Market value is can be given. Yes. Court other than the court has the idea market value. Yes. So therefore, there are issues about the market values. They are very in this country. So probably I don't deal with those companies. They are almost same thing. We can learn and have a market. So you have just to come to me. You guys are. They are based no. Then so whenever you go now business we have to go for that because otherwise with the law amended about 4 or 5 months ago, now lawyers are added for the undervalued company to pay this one. If the lawyers are doing there, then undervalued the lawyer has to pay the tax. Therefore, we now definitely ask our bank to go and get the market value. You don't do market value. So as we do it, we send them the payment and revenue, and then according to their opinion, they will that kind of done. You don't know that. They sometimes we don't accept the valuation. For the bankers, valuation they will accept. So other private valuation they don't. So they can be studied, but they do it. Basically, the property value is paid 20 million, they will say it's that. We have that. And we have the value, and general will accept. We have the principal 150. Every day of market value, the BNK, then 20 million, 15 million, but what you are from that doing on the garden, that's the garden. 100 look part of that. The Lanka, they have all market value, tend to be very large market. So you can challenge and you can get the assessors and so and so, but then you lost that something. Likewise, even for the market value of the value for the shares, there may be some issues, right? However, it is at least good to have that type of business because at least now people have to pay 50% of the fiscal. But before those laws come, sometimes they pay only for the very small amount of capital. Right. So, what do you think about the abolition of those nominal value and par value? Before 2012, share never had the true value. They had a fixed value. known as the target. Fixed value. Then make a share data. Then you become there's only a market value. So that may depend on the how success and how do we do this good profit making company or not. That and the assets can all will decide the value of the share. What's the good thing is that new law will be. If we want advantage and disadvantage of acquisition, power value or nominal value. For occurrences, we can cover almost many. That's why there are two sides. This side has a good more advantage, and we will go for it. One good thing is obviously when there's a market value, the investors can get a clear idea about the true value of their business or company or asset chance. So when there's only a market value, it's good for the investor. So they can get the true value of their company. If not, no one knows the true value of the company. One disadvantage is, yes, this is also a very common thing. How do you decide the fair value or market value of the initial? So sometimes people say when there's a par value or nominal value, so it's good, especially for the initial share. So they can decide some amount when issued. So now the law is when issuing shares. What the law says is directors can issue any number of shares to any amount they believe, but that amount consideration must be just and fair for the company and existing shareholders. That's what the law says. Be just and fair for the company and the existing shareholders. So I get that they can issue shares under some other restriction as in we discussed. So that's one disadvantage of abolition debt, and also there were some issues at the very beginning of the 2007 issuing the bonus share. So the act it says, yeah, should only have a mark. When we issue bonus shares, so what's the value? There was some argument. So, however, after 6 months of passing law in 2007, I think John Keats issues under with few other issues. Then the registrar in fact passed the figure saying that even though the specific section does not permit the company to issue bonus shares, when you take the Companies Act as a whole, there's no provision. Therefore, they pass a circular stating that companies can issue bonus shares. Now, following that, companies issue bonus shares. However, when you do accounting auditing and all, you have to get the fair value even for the bonus share market value. Right. So, right. By Section 49, Companies Act now in Britain accepts that companies can issue different type of shares. So what are the shares that companies issue, as you know? Yes, one by each. Preferred shares. You have some shares? Yes. Another type of share? Ordinary shares. Reviewable shares. Another type of share. Non-reviewable shares. There are a lot. Renewable preference shares, okay. Voting shares, non-voting shares. Convertible shares. Preference shares, non-preference shares. Yes, these are some of the shares, that's not all. So we have all the shares, preference shares, renewable shares, non-voting shares, preferred shares, employee shares. Right? You can add if you want bonus shares, golden shares. Those are some other type of shares. Then again you can see preference shares, preference convertible shares, non-convertible shares, partial convertible shares. Right. So anyway, that recognizes that companies can issue different type of share. Apart from that, one of the things that I knew about 3-4 years before Corona, we went to the BSAA, which one of you read, like you. Then I realized that at that time, NDB Bank has issued shares, the same audit shares for the two different kinds. One share 30, one share 20, the same. Because I worked out. First time Lanka, I couldn't share it. I thought they are not negative. So what do you think? But they said was to get more money because if you really want, then you apply for a 30 rupees per share. So when they make allotment, they first allot the shares to apply for a higher. If there's a balance, then only they make allotment for the 25. Therefore, they really with that if you really want to apply for a higher price and get more price. So this is good for the business shares. Right? So therefore, this type of tactics, right? So they also use the same share for the different price. Right. However, if the companies are recognized that the companies can issue different type of shares, and with the term of issue and according to the companies, some issue may get priority. However, if the term of issue is not clear, and if a particular shareholder can prove that they have priority, in law, all the shares rank equal. They can clearly prove there's nothing wrong. They will get priority. If they cannot prove, the law believes all the shares are equal. All the shares are ranked equal. In banking law, this is known as the concept of parallel. Right? Therefore, all shareholders are equal, especially at the event of winding up. Right. Just let also we know some of the special features of this special type of shares. Before that, we discuss why companies issue this different type of shares. What are the reasons for the companies to issue different type of shares? Why different kinds of benefit for this method? Right. Is that the only reason? We compare requirement, okay. exam. Maybe tax issue, ne? Or maybe about the voting rights. Ownership. Some kind of requirement of the group. That issue around the why they issue different type of. In fact, the term that for really not the real reasons behind the issue of different type of crap. Maybe the one, maybe access to and so. But we can discuss some common reasons to issue different type of shares. Those common reasons include one is obviously this is a method of raising capital. So they offer them for the general public. So they have to attract the general public. So people are inherently different. So therefore their interests are different. Therefore, to attract these different types of investors, companies issue different type of shares. I think that's the same thing you try to say, isn't it? Because there are some people they like to take any risk. Right? So high risk, high return. So they have a audience here. There are some people they don't want to take that type of risk, but they want to invest on shares like in fixed deposit. So they have a probably preference. Right? They have a fixed amount of dividend. Right? Maybe some investors they want to invest only in some duration only. So maybe renewable. So therefore, to attract different type of investors, companies issue different type of shares. That's the one common reason. There is some main reason that to issue different type of shares. Because you are becoming now, couple of becoming and then you have to right. So people, they are able to access different type of investors, companies to different type of shares. Another reason is, like you said, that the company requirement. There are some companies they don't want to expand the ownership, but they want to raise the capital. So what they can do? They want to raise the capital, sorry for much ownership, but they don't want to expand the ownership. They can issue renewable shares. Yeah, if they have a sector, they can redeem them. There will be no expansion of ownership. So that's another common reason. Another reason in Sri Lanka, almost all the preferred shares have no voting. That is used by the Sri Lankan bank, very nice. So there are many banks in Sri Lanka. They do want to raise capital anyway, but don't want to change the management. Management will answer to happy answer. They issue shares, special preference shares without voting. So chances are going to so the management can be the management until they are there. But they still can issue shares. So this is used by the bank. Main reason behind that is not to change the management. And also, this is also used by when there's an acquire or merger of companies, when the acquiring company want to help the company, then they issue shares for the previous company, but without voting. So they have to take the decision. So those are some common reasons to issue different type of shares. But as I explained you, another business people, another real reason behind issuing those different type of shares. Maybe some tax reasons, maybe some other killing people. But there are some common reasons to issue different types. So what is an ordinary share? basically, original shareholders are the real owners of the company. And this is also the bulk of the shares the company is issued. So original shareholders basically they have almost all the right to vote, right to dividend, right to surplus assets, and right to be a director. So all those rights are enjoyed by the original shareholders. Original shares are also known as equity shares or risk-taking shares. So why they are called risk-taking shares? Risk-taking shares are on this one. Why? Dividend rights. No, basically, so the shares, there is no guarantee that their investment will be paid back in some time. That is right. Share market is stable, then they are buy and sell. So that is for the older shareholders anyway, if the company runs smoothly, profitably, then they will get more dividend time. Right? If it's not, then they are not entitled for any dividend. Sometimes even the following year, if the document says original shareholders will be entitled to the dividend after paying off the preference shareholders for the previous year. Therefore, if the companies were not successful, then they have this. So that is right. So original shares are also known as the risk-taking share. But if the company is good, then at the winding up, they are entitled for more rights. Also, fantastic. But preference shares, what are the key features of preference shares? As the name suggests, they have a preference over ordinary shareholders. They have a fixed amount of dividend. Sometimes, if the document says, in 1 year, if there is no profit, still following year, they have to pay the people paying of the ordinary shareholders. And in Sri Lanka, in many cases, preference shareholders also do not enjoy the voting. Do they also have a preference that binding up, I mean, for the capital? So the shares they do for the capital. Preference shareholders are capital. According to the law, the preference, they only able to preference for shares. Right? For the capital, they will get the preference only if the document says. If they issue preference shares, the terms of issue says that they have preference for the capital, then they are impacted. Otherwise, basically, it does not permit to the capital. That is something else. The capital, debenture holders will get permitted, but not shareholders. Therefore, if the terms of issue says, if there are provisions, then they are impacted. There's no such provisions in the term of issue. So the law will be that they don't have preference for the capital, only for the dividend. Right? But we make sure that we know exactly what the accounting and auditing is standard. But for the law, they only have preference for the dividend, not for the capital. But if the terms of issue permitted, then they are entitled. Okay, law is not. Sometimes law and accounting working are different. Because of the binding of again, judges or lawyers never ever will think that the lease vehicles are assets. But you believe they are assets, right? For the law, they are liable. Finding up to be a livelihood law. You get comparing this assessed capital like it. So, what are the assessed? If I already put you from somewhere last year, okay, you see another guy, I don't know that. What do you do? Here, that's the guy. So, I'm not putting liability that way. Low. Accessible that in there. Please, I purchased a deviation. Ownership click below to someone else, isn't it? Complaint ownership on the deviation. Accounting of the year, here access the law that in there. So, according to the law, preference shareholders do not have preference to the capital if not provided by the terms of issue. Right. Medium share. I should have retained sometimes not to expand ownership. Sometimes when they are in the temple financial countries, also they can issue renewable share. So the shares are ready. According to the, they only can do if the articles of association permit. The company issues renewable share, then only companies can issue renewable share. So they are received at the option of the company or at the option of the holder or according to the document. If the specified date for the document, on that date they can be released. So non-voting shares may be any type of share may be without voting right. So deferred shares, also known as the founder share or management share. Deferred shares, founder shares, management share. The modern trend is not to issue this type of shares. However, still sometimes I have seen when private companies become public companies, for the respect for the original owners, they issue deferred. So they basically have more. The dividend that they have done as the other share. It is a respect owner for the founder. Or initial shareholders. That is why they are known as founders, management shares or deferred shares. The modern trend is in fact not to issue those type of shares, but in fact, as I told you before, when private companies become public, there are 2, 3, 4 individual shareholders. For respect for them, they can issue some deferred shares. For employee shares, it is also not uncommon for the companies when they issue shares, first they issue them for the employees. So when the shares are issued for the employees, so they are known as the employee share. Right? That is for more participation and for some other HRM reasons, right? So companies can issue shares for the employees. And also the bonus share. When companies have profit, they have 2 options, to declare dividend or to issue bonus share. That's the 2 options they will use if they have profit. So if they don't declare dividends, so they can issue share. So they are known as the bonus share because there's no imparted consideration. They are issued for free. There's no consideration. However, as there cannot be a nominal or par value for the shares after 2012, whenever you make calculation for accounting and auditing purpose, even though shares are issued freely, you have to take the market value of the share. Right. So those are the some type of share and the reason to issue different type of share. So we already have discussed the things a person can be a shareholder by being the name in their application for initial shareholder. If a person's name appears in the application for O is the amalgamation proposal, so they are known as the initial shareholder. Those are the type of shareholders, they may not be fully paid initial shareholder. So, however, they have an obligation to pay for their share if company may fall. If they have not paid, especially in the winding up, the liquidator definitively falls. Then they have a duty to pay. If they already been transferred, company may have issued some shares to A transferred it to B transferred it to C. Now, company is now in that winding up process. The shares are not being paid. Who is liable to pay? Initial shareholder or current shareholder? They are the current person, they are like that even initial shareholder. Yes. Two price was 10 rupees, now it is 100 rupees. Then Colombo is on the lab. By transferring, people can be a subsequent shareholder. Or people can also buy shares by making application. Right? So what is this application according to the contract law? According to the contract law, when special limited company issue shares, they will do it by way of prospect. What is the prospectus according to the contract? Is it an offer or an invitation to trade? Prospectus is an offer or an invitation to trade. So one very simple, basic, but complex, right? The concept of contract, the difference between offer and invitation to trade. It's one basic but complex situation in Srilanka. There are thousands of litigations. There is a slight difference between offer and invitation to trade. So they can get public but they believe as offers are not offers in contract. So paper notice, tender notice, display of goods, display of prices, right? Auction sale, right? So none of them are offers in contract. They are known as only an invitation. In contract, what is almost realized. Right? Apu tama hai mere ko ye offers karte. Abhi aapko dikha kitne mein offers karte. In our contract overall, the true situation is always realized. The same way, prospectus is only an invitation to trade. It's an invitation to trade according to the contract laws and also according to the company. These investors, we make offers to the company. Then we make offers in the check or bank draft. Then the company has a right to accept our offer or reject it. If they accept it, then they will make some allotment. That allotment is the acceptance. Then there is a contract. However, they have a full right to reject because we have made the offer. They have a right to accept it or reject it. If rejected, there will be no contract and you have no right to sue. Because there will be no contract. So that is how the procedure in contract law. So allotment is the acceptance. So allotment based on enforce human capital because when allowed, then there's a acceptance. Then there's a acceptance. Then their name has to be entered in the index list. When company make allotment, there are some rules. The companies can only make allotment if the minimum subscription is received. The minimum subscription is the minimum number of shares to be subscribed to make allotment. So whenever company issue prospectus, they set out the minimum subscription that is to be allotted or subscribed. If not, minimum subscription is received, then company cannot make any allotment. So basically, with almost all the prospectus, there is a clause related to the minimum subscription. How companies minimize that risk? Or how do they get guarantee? So that's why many companies enter into what is known as an underwriting contract. Underwriting agreement. Underwriting agreement area में an underwriting agreement is an agreement. There are some financial companies, they give guarantee that if the public will not subscribe, we will. Then there's a guarantee that minimum subscription will be received. This company can allot shares without any doubt. Therefore, that is why some companies they enter into the underwriting agreement. Then there's a guarantee that they will receive the minimum subscription. Then only they can make allotment. The general public have not subscribed for the minimum subscription, then the companies cannot issue shares, cannot make any allotment. And then all the checks or whatever the funds they received has to be refunded to those owners within fixed period. If that did not refund within 75 days, then they have to be refunded with interest. But if done within 60 days, that can be refunded without interest. And also, if they have not paid within 75 days, the directors are liable for the outside. When issue shares, now there's nothing called authorized capital. So it looks like directors can issue any number of shares for any purpose, for any people, right? For any amount they will. Even though it looks like, it doesn't say that it is not supervised. So there are some rules, regulations, laws, where directors have to be mindful when they issue shares. So those restrictions are imposed by the Companies Act itself and by the common law and also by the Articles of Association. Subject to that, only directors can issue shares. Okay. So as an example, they can issue shares. The one thing we already discussed, if minimum subscription is not received, then they cannot make any allotment. Under section 187, we discuss next week or week after, directors have a duty to act in good faith. And also, they cannot use their power authority for improper. Therefore, they can issue shares to raise the capital. For that, directors can issue any number of shares, any amount, and so on and so on. Act says they have used their authority for proper purpose. So the proper purpose to issue shares is to raise the capital. Therefore, if they have issued shares for some other reason, they are not liable. Therefore, Companies Act has some restriction on directors when issuing shares. The articles also may impose some restriction for issuing shares. So, Companies Act has another restriction with what is known as the preemptive right. Right? When companies issue shares, which rank equally or above the existing issues shares, then they may be available for the existing shareholders for a reasonable price, reasonable time. Then only they can choose it to the third party. They are known as the preemptive right. When company issues shares which rank equally or above the existing shares, they first directors have a duty to offer them to the existing shareholders. If no requires subscription receipt, then only they can make them available for the third party. Likewise, there are some restrictions of the Companies Act and the Articles of Association. So this is the one case that we can also discuss it under direction duty. In this case, there was a company where directors of this company wanted to acquire another company. The directors of A company want to acquire B company. The minor shareholders are also with the directors, but major shareholders were against the takeover. Directors wanted to make a takeover with the success. But they cannot pass a resolution because majority were against the takeover. The minor shareholders, they were with the directors. So what they did was, the directors issued large number of shares to the minor shareholders. Then they become majority, pass a resolution, and made the takeover with the fund. Now minority, before the share issue majority, file a case. They file a case to make the share issue null and void because it is not done according to the Companies Act and they have breached their duty. The argument was they have not acted in good faith and they have used their authority for improper purpose. What do you think? Who has the authority to issue shares in companies? Obvious directors have their right. Take the color of any number. So directors have an unfettered right to issue the shares. The right of the authority of the director. But in this case, court decided that they have given that right authority by the law to raise the company's fund whenever necessary. But here, directors have issued shares to dilute the voting fund, not to raise the company's fund. Therefore, they have used their authority for improper purpose. Therefore, court declared the share issue was void and cancelled the share issue. Therefore, even though you have authority, you have used it for the proper purpose. So later, it was even developed as a proper purpose doctrine. Right? One of the they are used to proper basis. Not only in companies, or even in politics or governance or whatever, or maybe as a political or whoever. With power, you have to use it for the proper purpose. We have to they create the artificial majority. Right? Because majority shareholders were against the state government. But the huge share of the minority, they create the artificial measure. Very few to our parliament. Artificial measure. They have created, not the natural ordinary measure. So artificial measure. They have not acted in good way. Once they give to the legislature, both will take the two camps. The ultimate parliament, not the bag again. I don't know if it is true or wrong. Right? Basically, once law is passed by the parliament, it can be discussed at any court. That is common acceptance all over the world, except in America. USA the programs, US actually if they violate the human rights, the American federal court will cancel. But in any other country, it is believed that parliament is free and court has no power to discuss. However, court has the power to interpret. It is not something discussed or something. The interpretation power is given to the court. By way of interpretation, sometimes court try to uphold the rights of the citizen of the country. On the other almost destroyed it. I think valuation. Have you heard about the monitoring and valuation? Ever? I will ask the Sanjay to include the subject in this post aspect. But people don't know about the so that monitoring valuation is also right to be covered. So you will have ever done what on our past monitoring valuation is more than that. It monitor evaluate at the very beginning and at the middle and at the end. You will now use the monitoring valuation later. Only but we get it. Monitoring and regulation draft bill is also passed, but it is not passed as an act also. Before any government project, there must be an evaluation officer and they have to evaluation it was a monitoring it's more than the living, but it's the living subject I was hand in hand. So I asked 2 times Sunday to participate in the monitoring and regulation topic and the monitoring and regulation the fantastic Sri Lanka attached to the university. Interested, you can have a master's there. You still got college in the common next, which are the real cases. There are so many available for the later. And also in Sri Lanka, if we pass an act, there's a requirement of 3,000 evaluators. So we really easy to get that. Government could get. One not run the work, the masters can run the qualification us. Take the for monitoring and evaluation. That's a very good thing. Okay, probably. If you are interested in international jobs, it's almost a must be done. You will be interested in the knowledge of the yeah. I think subject according you will endure. So it's a good option for you that they have masters. And that masters because there's no difference between that. Well, we think that the fixed rate. Otherwise, more play. I mean, for the people not get very good again. So we will be again, but people won't be. So, will make us Under Lanka, I have to run and because it's only some years and major thing. Because other good side is national. So when the exam are good side, you don't want that as a money. Lanka, the revision is done in Monday. Instead of doing MBA, so and so, like MBA is widely accepted for you, so you can do masters in monitoring and evaluation. So the first institute in South Asia is at East Coast of the South Asia. There's a one center in Dubai. So this company allots shares without minimum subscription, so they are not than. But they receive the price consideration within 21 working days. They have to allot share for the shareholders and include their name in the index register. So how do the companies decide the consideration? Even for the company law consideration, consideration as a wide meaning very spiritual contract. Because shares also can issue not only for the tax. They can issue for other type of bill of exchange or even for the future sale. Likewise, consideration very largely. So that also consideration. So how to decide the consideration? The directors can decide. Again, it's the power of the directors to decide the consideration, but no says it must be just and fair for the company and existing share. If they can prove that it is fair for the company and existing shareholders, then they can issue share. However, subject to the preemptive right, they be available for the existing shareholders for a reasonable time. Right. So those are some of the laws in the companies are related to the hold on share. So the board is definitely a power authority of the board of directors to issue shares and to decide the cancellation of shares. They can issue any number of shares. Now there's nothing called authorized that. There's no limit. So the board can issue any number of shares for any person they think for the consideration that they think they are for the company and the existing shareholders. If the shares are issued other than the cash, then the term of issue must be set up. Term of issue must be set up. And once the term of issue is set out, term of issue becomes a part of articles of association, then it's a contract, then they are bound by that contract to the government. If it's your broker, the company can well get their amount. And within 20 working days, the company has to inform the registrar general about the share issue and the consideration they received and the new capital accordingly. those are the rules related to the hold on shares and the issue of shares. So there's a one difference between the hold on share and issue price and the price of the shares on call. In this case that we discussed, first the company has issued share for A for 10 rupees, that is the initial or issue price. Then she has transferred it to B, B has transferred it to C. Within that they were not paid. Now compare in a bankrupt situation at the winding. Then who is liable to pay the share to the company? In a winding up, liquidator definitely has a right to call on shares if they are not paid. For unpaid shares, he can make call. Then who is liable to pay this amount? What do you think? What do you think? Next. A. What? But if you don't hold shares, not within 6 months, you are not even a shareholder of the company. According to the definition of the shareholder, right? The shareholder is a person whose name is in the share register. And your name is not in the share register. We have already found. The man shareholder is not definition. Initial shareholder is transfer transmission you are not a shareholder. Right? Why is not the case on shareholder contributor? That is for the person who has the shares within last 6 months. But within you will even past the 6 months. Then even you don't have a right at the winding. Basically, for the call on shares, current shareholder is liable. Current shareholder is liable. When the company make a call, current shareholder is liable to pay that call. However, call on share is different from the issue price, issue of share. So she is still liable for the 10 issue price. That probably comes from the principles of contract. Because you have a contract with the company to pay the issue price. Right? So that you may be done. But probably for the call on share, the current holders are liable. For the issue price, the first shareholder is the shareholder may be liable. So it is that is because the law believes there's a contract between the initial shareholder and the company to pay the issue price. Thereafter, the current shareholders are liable to pay the price of the share. Right. Now we discuss some other concept of company law, distribution, dividend, and also what is known as the holder. So what is meant by distribution of a company? Probably section is it 56? Yeah. Distribution again defined by interpretation section. The distribution is interpreted by the interpretation section, section 529. What is meant by distribution by the company? These are some of the important provisions for the auditors and accountants. Distribution, payment of dividend, and the solvency test. Probably good companies do have a separate statement capital account as well, right? Right. So this is the interpretation of the distribution of the Companies Act. The direct or indirect transfer of money or other property. The direct or indirect transfer of money or other property, it does not include shares. To or for the benefit of the shareholder, or the incurring of a debt to or for the benefit of a shareholder in relation to a share or share held by that shareholder. Either by means of payment of dividend or redemption or any other means. So therefore, distribution include. It does not include the transfer of shares, right? So transfer of shares is excluded. It is not an issue, right? So any other, right? Any other transaction, whether money or property or any other means, if it is paid to the shareholder or benefit to the shareholder, it is a distribution. Because of the shares he has in the company, if there's any type of transfer of money or other assets to or to the benefits of the shareholder, is a distribution. Right. So, then what about the payment of dividend? Is the distribution or not according to this definition? Yeah, distribution, right? It's the transfer of money or other property for the benefit of the shareholder because of the shares he has or he is in the company. So therefore, dividend is also the within the meaning of distribution. The meaning of Section 60 says about the payment of dividend, right? So dividend is paid out of what? Out of capital or out of profit? Out of profit. Right? So that's the difference, right? Distribution is basically out of capital. Dividend is also a distribution, but it is paid out of profit. But there are some companies they have paid dividends out of capital as well, right? So they are legal, they are not fixed dividend payment, right? But sometimes there's one case where they have mentioned in their prospectus that they have paid dividend even for, let's say, like even for the pornography. If I get they give again your prospectus case that. So investors will definitely invest, but shares in such a contract. So some investors in that hold some shares. So because they knew that this company has paid dividend even for such a difficult period. But once they hold the share, they will not pay dividend. When they go to one, they do that. During those 2 periods, the company has paid dividend out of the capital. So this by the case, the company was liable to pay. Because in the prospectus, you cannot have such an untrue false system. Because people invest in the companies looking at the prospect. Therefore, they have all the reasonable ground to believe that they are true and correct. There are untrue false statements, they can sue. So in this case, to say that they have paid dividend, but in fact it's paid out of capital, was declared as an untrue false statement. And the company was liable to pay for those investors. Therefore, yes, it has to be true statement only in the prospectus. Otherwise, not from the director, even as the accountant auditor, you are also liable for the content of the prospect for the third party. Right? So dividend is a payment out of profit. Right. So what is important is so it's not mentioned here, but I want you to read how to make a distribution. How to make a distribution. Section 56. All again over distribution and current market. So you need to know that as a business and accountant for the how can you compare data? How can you compare data? Can you compare new calculators? Who has the right to? Both are required. That is the honor. Before any distribution, you can see it has to be approved by a board resolution as well as by a OD resolution. Therefore, before any distribution, both have to approve. Not only the board of directors, but also the shareholders of the company. Board has to pass a board resolution. Shareholders have to pass a OD resolution. Then only they can go for a distribution or even the dividend. Dividend is also a distribution. Both have to approve. And then, without requirement, that can never happen. Both have to satisfy that immediately after the distribution, company will satisfy the solvency. Right. If not, if company don't satisfy the solvency test, solvency test is done by you, right? So because of the but the future they have to get it. The responsibility is the board, but the is to get it. But before any distribution, board has to pass a board resolution. Shareholders have to pass a board resolution, and then board has to make a solvency test, and they have to satisfy the solvency test immediately after the distribution, and then those directors have to sign a certificate of solvency. So if company backs up after the distribution, then those directors who sign the certificate of insolvency are personally liable for the loss of the therefore, it's such a formal procedure to make a distribution. Therefore, for any distribution or dividend, companies have to satisfy the solvency test. So what is meant by solvency test? Have you ever done it? Okay. But I don't understand. What is meant by solvency test? Those who done it. Yes, I think so. It's a 50% of the problem. The other problem. Yes, but you, but you said was on the other, weekly. And there's the balancing test. Both that. So, the general English term, common English term is the insolvent. But compares access of the solvency test. Even in Srilanka, tapi backup gunmat ke lidah nene. Tapi actually क्या ने नुगुनmat क्या? नुगुनmat पावे के मतलब solvency test. Insolvency test right? The common English term is the insolvency. But access about the solvency. So it checks about the financial health of a company. Right? So the law believes that the director should be able to check whether the company is financially healthy at any given time. The board should be able to get it done at any given time because they are business people. So this test is to check whether the company is good, whether it is financially healthy, whether they can face this as they all do. What about their assets, right? So such a simple test, especially for you people, like just nothing. අපි තමයි term වල අලුත් කියන්න පුළුවන් නේද? ඔයාලා මේක කිසිම අලුත් දෙයක් නැහැ. Very simple test එකක්. But company lawyers believe that this is the golden test which runs throughout the company. Right? ඔයාලා නම් මේක කියන්නේ which the value of the company that is greater than the history of the capital and life. Also, I'm going to give but we compare lawyers believe that this is the golden check that runs throughout the company. Right? So we discuss the importance of solvency test after that. Right? So they can get this.
Excuse me, sir.
Generally, solvency test is done by the company's auditor, right? It has some special duties, duties to make audit report. Apart from that, those are some other duties of auditor to do the solvency test to decide the market value of the animal. So those are the roles of auditor. So who has the responsibility to make sure that the company will satisfy the solvency? Who should get it done? It does will do it whenever someone asks. Sir, you get the board of them. So the company law complaints are given that power to the authority to the responsibility to the board of directors. The duty of the company, right? So you can see case, right? The board, right? The board. Board they recommend right? It's like simply like when you drive a bus. If it is running out of petrol or fuel, then who should be careful about the bus? Clean out the diesel or petrol parking pit. Is it the driver, passengers, owners, or someone else? Obviously, right? Because he runs the bus. Right? This is not the duty of the owner. It's not the duty of the passenger, not the conductor, no. Right? The driver should be. Right? How long it can go with the big demand? Where is the next factor there? So it is up to the driver. Likewise, business are run by the board of directors. So they should know how far the company can run. Right? Whether the company has its sufficient fund or what, right? So complete the duty of the directors to decide whether the company satisfy the solvency. So when satisfying the solvency test, so the section 57, yes, what is the solvency test and how company can satisfy the solvency test. So it says the company shall be deemed to have satisfied the solvency test if it is able to pay its debts as they fall due during the normal course of business. Right? If the company can pay its debts during the normal course of business, then that company is financially good. Right? So it satisfies the solvency test. So this is known as liquidity test. So the law says and, not or. It says and. Therefore, it is only a 50% of solvency test. The other 50% is the balance sheet. Right? So it says the value of the company's assets should be greater than the stated capital and the liability. So that is the other part of the solvency test. Because some companies may be able to pay its debts. However, very few assets. So such companies do not satisfy the solvency test. Assets should be greater than the stated capital and the liability. Reverse also can happen. Some companies may have enough assets, but they cannot pay their debts as they fall. Day-to-day business is not success. So such companies also do not satisfy the solvency test. Therefore, to declare that the company satisfies the solvency test, both limits should be satisfied. They should be able to pay their debts as they fall due, and also their assets should be greater than the liabilities and the stated capital. Right. So then only company can satisfy the solvency test. And also, we determine whether a company will satisfy the solvency test. Right. You can see do any fraudulent action. So it says the board shall take into account the most recent financial estate. We can decide in looking at one of the profitabilities, right? The most recent financial estate, and shall take into account circumstances the directors know or ought to know, right? Because they are business people, right? So all the facts they know or they ought to know as a business team, as the drivers of the company. And may take into account a fair valuation or other methods of assessing the value of and other assets and liabilities of the company. Therefore, we have enough solutions to get it done and get it done fast. So, even though this is only one topic, one subject, one section, section 57, it relates to number of other sections of the company. Like this one, we just discussed what is solvency test. So, solvency test consists of two parts. First part is known as the liquidity test. That is, the company should be able to pay debts as they fall. Other part is known as the balance sheet test. That is, the company's assets should be greater than the liabilities and the stated account. It is not sufficient to satisfy one thing, because the act use the term and. Right? You can see they use the term and, not all. Right? Therefore, both tests have to be satisfied. There may be some companies, they have enough assets, but cannot run the business. So they don't satisfy the solvency. There may be some companies, they run day-to-day business, but they don't have enough assets. So they also do not satisfy the solvency. Right? Therefore, to make sure that the company satisfies the solvency test, they have to pass both tests. And in determining the solvency test, the experts have to take all the current documents and fair value method of the assessing the company's value. Right. So I said that it is goals and said because even though it's one section, it relates almost all the important section of the company. Say as an example, we have already discussed two sections. What are they? Before any distribution, companies have to satisfy the solvency. Before making any dividends, companies have to satisfy the solvency. The directors have to sign it. They'll find that immediately after the dividend payment, company will not pay up. It satisfies solvency. Before any distribution, they have to make sure that immediately after distribution, company will not pay. So they have to declare that state. To do that, they need to get the solvency. Apart from that, there are number of other sections. What are they? We have discussed some of them already. Before entering amalgamation proposal, right? The board has to satisfy that immediately after the amalgamation, company will not bank. So before you made the transaction, right? The company has made a transaction. Before that, they have to make a declaration that company should not bankrupt or should not insolvent immediately after entering into the major transaction. So likewise, there are so many number of sections, right? Just after the reduction of risk-weighted capital. It's not a good thing at all to reduce risk-weighted capital. However, the act permits, right? If company decides to reduce the risk-weighted capital, one main requirement that the company's board has to satisfy the solvency test. That immediately after the reduction of risk-weighted capital, company will not bank. Right? If company decided to reduce its own share, then they have to do. If company is going to repurchase its own shares, then they have to do. If company is going to give any financial assistance, then before that they have to satisfy the solvency. So that is why lawyer says the golden thread which runs throughout the compliance. Before any material distribution or dividend payment or whatever, or any other transaction like any transaction, so both have a duty to satisfy the solvency. So that definitely protect the stakeholders of the company. So we can see some of the, so this is the special capital assets to be greater than the liabilities and the special capital. So some sections, not all. Right. That relates to the solvency. Distribution by the private company, distribution to shareholders. Distribution to shareholders when the company does not satisfy the solvency, then the directors have to make the responsibility. When the repurchase, giving financial assistance to purchase its own shares under Section 94 minority buyer price, then you can have clear transaction, amalgamation, right? So those to be added. Right? So before any payment of dividend, right? Before any of those things, companies have to satisfy the solvency. Then only company can enter into start the company. So when company get these solvency tests done, it's the duty of the directors to get the certificate for solvency and sign. Directors who sign the solvency test are liable if we went wrong. Whether shareholders or whoever affected can sue against the director. Right. Then the capital maintenance of the company. So why do you think it's important to maintain the company's capital? Company's capital belongs to who? Belongs to the company, anyway. Provided by who? Yeah. So it is there for whom? Huh? Yeah. It's for the shareholders, probably law will not maintain capital in this way. Even though we say that the shareholders are the owners of the company, probably I have already discussed with you that owners are the shareholders are the owners of the company only in the solvent company. When the company is insolvent, its owners in fact creditors. They have more rights than the shareholders. There's no guarantee for the shareholders at all. Creditors have right. So, company's capitals are also made for who? Made for the creditors. After paying all the creditors, then only if there is any surplus, then they are distributed among the shareholders. That is why special capital was a part of memorandum. When there was a memorandum of association. Memorandum controlled the external affairs of the company. Object was stated capital was a part of memorandum. They were public documents available for anyone else. Therefore, when we have an example, so there are bankers here. What will you consider if you give a loan to the company? As a banker, what's the main thing that you will have? There is one about this country. Yes. This country, the banks, they are not able to give any assistance for the business people also. Right. They go behind the employees, monthly salary people. I can't believe this. Right. Bank capacity in the bank. So we don't do business. We are employees. There are people readily available waiting for the loan. So they are not ready to make such a nice plan for them. ඒගොල්ලන්ට දෙන්න එහෙම මහා ලොකු plan නැහැ. එක plan එක දෙක ඇති බැංකුවක දෙක නෙමෙයි. එන්නේ අපි පස්සේ plan මොකද කරන්නේ කියලා මේක අපිට දෙනවා නම් දින 12න් උඩට කරහත්. business කාර්යයෙන් ගෙන්න ගියාම දින 12න් උඩට පහත්. monthly කරන්නේ දෙන්නද? So they are the people they really want to sell. Right? But I don't know the attitude of this bank of this country. They go behind the salary table. One hand, they don't do the business. And the business people go behind the money. Obviously, they have to get it late. So in those people, you know, sometimes 5% per month, 60% per year. In Sri Lanka, do you think that there's any business? I don't think you are a good business as a 60% short. Except that, I don't think any other business may run the man. You're going to define bank of very unfortunate. Bankers have to face their insurance people have to pay their one accident happened. The insurance people are to pay for 200,000, 500,000 for the victim who break their legs so hard, or sometimes even that. But they pay on millions of dollars. Very unfortunate. This country is bankrupt, and in this situation today, that we apologize anyway, including myself, right? To give you such a band of knowledge, that something is very difficult to get to try to be fair. But I wanted to say, Islamite, it is not an act of uneducated people. Right? The main contributors are educated so-called people. So we have a doctor, they don't know the company. We have lawyers, they don't know the legality. We have doctors, they don't know the medicine. One station, so it is educated people that make this country very successful, not uneducated people. Always do that, but there's nothing I can apologize. But try to civilize that system so that you can make this country with a faithful government. The month and like a give up again, you can have to the station, every station again, you can not appeal to see it. Leave that in the higher will pay that one. We bank of country. You should change the one or pastor and the Kalina. Right? And it's even structure on the internet. So we have such a good people and real citizens that they are still safe. How do they have all the people try to either moment. Right to another officer at the university as a doctor. In charge of history, next to the right side. So there are the universities are governed by the controlled by the union people. When I get to these students, I can't believe. No one take actions. All what actions they have, I put come on here. So can't harm in this. You buy the and that's the one husband the Pakistan. I get that is my influence, but they I think that the discipline must be very big. No mind the government, only couple. You don't have a couple of money. You accept that. And that's the one inquiry of Kaltana. Pending inquiry. It has happened first time in the university. අනිත් අර හිතාගන්න එහෙම පුළුවන් ද කියලා. So I transfer it, cancel the institute verify. Internal discipline matters. You don't need to compare with the laws of the country. Even though students never ever will be because they are part of the authority of the university. Okay, so the management has to take this. It's not done for all 50. I hear that. I mean, it's not something wrong with the president or something as politics. In the university, you can do it. It's never done. It's not rules, regulations, really difficult matter. There are 1/10 part of those things we not have to do. The masters, the professors, the universities, the faculties, all are following those discipline union. Actually, that's right. So you don't even know what will happen in the next 2 weeks. But we still have enough by now. They have not done anything. So, not all what we hear at next year, they should make people does a community. Right? Now, you relax in some of the to what I am making. So, what that's the government here now. You have to not part of the environment. But some people come to those things for those type of privileges as well. Therefore, they just remain and they just want to run their tenure for 3 years so much. However, for the ragging, I think that is extendable 5 years we have said, and now there's a 24/7 number 90 times there. Any person, even outside, they can compare and special things are established under the focus of the BID. When they are supposed that we directly go to CID. So after 24 years, we can at least include them. Taking exposed past 1998, it's 2023. Now only it is implemented. If we have to exam, then some underground will be carried out. The other was. I'm going to beat out the high court came to beat up when cases where high court rejected the beta. So, power taken then was permanent, but for probably near future, so the government will take tough action against the union. I will have done a very big okay. So, private using I don't know the tagging is not there, but I have seen bullying is. That is also should not be among the data field. While I talk to among the some are passes. We did it on it. Part of bullying to trust, yes, that's only the birth. Those should not be happening in education places. So those are type of food that should not be there. Right? So those type of things I would be allowing you to go to place and all. But sometimes you never know how much they are stressed because of those type of simple issues. Because this is the country are no one thinks of mental health of people. Mental health they don't think about the mental health of the students. Although the students they never know where they are. It's a million problem. All the time in the all the time is nothing anyway. Right? You don't need to go there all the time and just get it there, yes, and so don't worry about that. So I always ask my students, right? So you have your own type phase to success. Don't go behind those type of document, but go behind the experience. So that is it. Experience right for the right, not the document at all. Because we all know Obama became president at the age of 41, I think. now. I think she retired at the age of 40. Right? But Biden became president at the 7th. So therefore, there are different phases of life. How on this era is done it? Somebody can do that. Having been the era, I do see that one. But anyway, it's good to complete to A level by 18. Thereafter, you are a major. Take an I will run accept, but no one takes from one incident. I mean, I'll give you a power to do it. It's the Hazin Dana Mika, then this can be seen. Take a try. Oh, now everything was everywhere in the world. Coming excellence, there are more than 180 countries over the world. But they issued result to the second basic. Other Srilanka next year, okay, result to the other than online team. Adiyada da dollar give $200. That's the system. These people even don't know we are the next order election, we are the next patient election, how many times that will postpone, right? So they know nothing about the mentality. I don't know who will get benefits. Those 1 month postpone. Honestly, is that any part is good benefit? Second time, you know, man, it doesn't hit up data. One time I take up young idea to a margin. I paper name, so I don't think that will benefit anyone. Right. So, sometimes capital are definitely not for the, I mean, at least not only for the share. Right? Most affected part of capital of company is probably creditors. Right? That basically look at the stated capital of the company before they decide to give a draft for the capital. Right? If they look at the stated capital, like the bank will look at our salaries. For the content, they will look at the stated capital of the company. Sometimes some banks even agree with the content. Right? The company wants 100 billion, so they make just wasted for the more than 110 billion. So what like 9% of what? Right? So therefore, they will grant loan looking at the bank stated capital. Because it is there for the credit. The company pays, then they know that they have their capital. And sometimes when some bank, when they give a huge amount, they even enter the contract in the company. Right? They enter the contract that they will not reduce the stated capital. Because it is plain for them that just in case something happens, they have that. But I don't know about the bankers' calculations that they will get it. I got another transaction about 2 weeks ago at the culture NPV. Yeah, those people have taken loan, maybe about 10 years, I don't know, 7 billion. After 10 years of payment, they have default some payment. They have paid 8.1. This gets in the loan. I anyway asked you, did you discuss and you have a financial ombudsman and so on? But really those people who are about to deal the country as well. I'm not telling. Taken 7 million. After payment of 10 years, when they go to social, they have to pay 8.1. There were some people anyway. And also with the settlement fee. So you know, if you pay, there is still saving that. Very uncomfortable. So the bankers have sometimes from the but anyway, those are the things happen. Right? But anyway, the bankers, we know that they also have to take action. That was nicely explained one day by one of the people of the professor. He explained it very nicely with the example of the train. When you are traveling in an emergency, when you are with the child or son or daughter, when they have a safety equipment, to whom you have to be first? To you or your son? And you have a big casualty. Some oxygen masks they can be doing anyway. First, you should wear. First, you should fix, right? Not wear some other, right? So he says, when the banks are also in such difficult for such the countries happening. First, they have to protect themselves, right? Otherwise, we never know what will happen. So he explained it very nicely that we right. Therefore, that is how he justified the high rates of the banks. It was discussed about 1.5 years ago, where the increment of interest rate in the fixed amount. Which it was argued we gave that example, right? So first they have problems. Therefore, that part is also there. But still will be voluntarily going to pay. You definitely have to honor your customers as well, right? Because they have paid 10 years and they have come to settle because they have to pay the funds. Right? Is it such a good thing to pay ask them to pay the settlement fee? Right? Because for the banks are also in need of money. Right? So those type of things are the bankers pass those messages to administrable people, right? So people are looking at those unrealistic, right? So even though there are persons for the early settlement fee, I know at the time of the your loan, you can negotiate. Some people, right, they don't have that cost in their it is again those innocent people who want to question with the bank, the bank then will incorporate such costs. If you want, you can after that exclude that cost. Sometimes bank will exclude. But if you don't question, they will definitely be hanged. Right. So, the size capital should be properly maintained because that remains affect the creditor, apart from all the stakeholders, for the result of regional law, global issue. Right. So that is why company's capital should be properly maintained. So company's capital consisting of the share capital and the loan capital. So share capital refers to the amount of funding a company raises through sale of shares or stock to public investors. Right? So share capital constitutes the main source of equity financing and can be generated through the sale of common or preferred share or sale of share. The share may be different type. So those are in fact not relevant today, but that is a big program I have mentioned. For 2007, there was something called authorized share capital. So that is the maximum amount of share capital the companies allowed to raise is called the authorized capital. So that's only that amount the directors can issue shares. Cannot issue more than that. But today there's no such restriction. There's no but. The directors today can issue any number of shares. Then subscribed share capital means when the company prepares to go public by issuing for the first time, then the investors can submit an application expressing their desire to participate. So subscribed share capital refers to the monetary value of all the shares for which investors have expressed an interest. So those are the subscribed share capital. So out of them, issue share capital is the monetary value of the share stock the company actually offers for sale to investors. Even though they only can issue some part of the authorized capital, then the jet public can subscribe. So they are known as the subscribed capital. then out of them, the company is not required to allot shares for all the subtitles. Right? Whoever the alloters are known as the issued share capital. Right? So therefore, they all are part of 1982 Act. Today, none of all authorized capital issue capital are covered. There's only one type of capital known as the stated capital, which is clearly defined by the section 58. So, stated capital is the total of all amount issued by the company or due and payable to the company in respect of the issue of shares and in respect of all of shares. So the companies that follow good accounting practices, they maintain a separate stated capital account as well. So, stated capital signifies the value of the assets received or receivable. If they are not paid, receivable by the company on the issue of its capital. So, here share means the any type of share, right? Because companies can issue different types of shares. Share means any type of share, not only the equity shares or the shares, but to any type of share. So, when determining the value of the share, it is again the duty of the directors. The board of directors is charged with the duty to determine the value of shares. The directors can decide it. Before issuing shares, the board is required to decide the consideration for share and to resolve that in their opinion. So, this is a requirement. The price at which the share is issued is fair and reasonable to the company and to all its existing shareholders. So the directors can decide the number of shares they issue. There's no limit at all. And also they can decide the value of share, the consideration. The only thing is, according to section 52, so it must be fair and reasonable to the company and all existing shareholders. So that's only a market value from 2007. So now we know what is the stated capital, right? So the general rule in company law is that capital should be properly maintained because that's the only thing for the creditors. If company went bad, right? So that it affects almost all the stakeholders of the company, and as I said, may affect the country, region, or global. Therefore, it is a fundamental principle of company law that the company's capital should be properly maintained. It should not be reduced. However, there may be some reasons that companies might have to reduce the stated capital. In such a case, the Act let the companies, permit the companies that they can reduce the stated capital, but there is a proper procedure to do. Before 2007, there was a same procedure. Apart from that, companies had to go to the court and get the permission from the court to reduce the stated capital. It is such an important thing for the company to maintain the capital. Therefore, companies have to go to the court, right? And with the court permission, only company can reduce the stated capital. However, from 2007, there's no requirement to go to the court. So it's a good thing, right? However, the rest of the procedure still have to be followed, it's still the same. That has to be passed. But there's no requirement to go to the court. So, the Act says how companies can reduce the stated capital. So, why do you think the companies have to reduce the stated capital? Then it should not be that. The general principle of company law is that stated capital should not be reduced. However, there may be some fair, reasonable situations that companies have. Then only they can do it according to the manner provided by the Companies Act. So there's a very strict procedure to reduce the stated capital. So you can think the seriousness of reduction of the stated capital because before 2012, the players had got the court to get the terms. But now you don't need to go to the court, but still it is tough. So what are the share buyback and the reduction of stated capital? Yes. So when what will happen when there is a repurchase or redemption? Definitely, it affects the stated capital and reduces the stated capital. Right. Change the only the public holding that we have 1 billion of stated capital and 700,000 hold by public and 300,000 hold by the company. If we buy that, only the holding percentage will go up, but 1 billion will stay. Right. So, however, doesn't it affect the stated capital? Okay, the anyway, that recognizes that and there's a separate section for the return, separate section for the redemption, right? And also the law believes whenever there is a repurchase buyback for redemption, it affects the stated capital. Therefore, the similar procedure have to come. When there is such a situation, the company has to follow the similar procedure. Apart from that, when there is a redemption, it has to be authorized by the authors of association. Otherwise, company cannot do renewable. Fine. So, the procedure to reduce the stated capital, you can see a company can reduce the stated capital by passing special resolution, section 59 of the capital, right? Therefore, the company cannot do it, directors cannot do it, simple majority cannot do it. 75% shareholders must agree with 15 days prior. The companies are required to pass a special resolution. So both cannot do it. Next, it's only one requirement. Then 60 days before passing the special resolution, public notice must be given. Right? 50 days before passing resolution, public notice must be given. Who read papers? It's okay because yes, I could make it a practice for my own civil action. Again, so I hope they read online, but I don't know. Because I would get your life from Baran because Baran must learn anyway, after month given. I will say, you get there. However, we believe that you read them online, but I have a strong doubt whether you really read online answer. If you read online, it's okay, right? Anyway, I just need to make sure that just read online, no physical papers. Maybe tomorrow or the day after tomorrow, you will see the public notice of reduction of the stated capital. Because what you do, learn, read this class, it in fact happen. Right? Just to make sure that you will see, just have a look on papers. So especially basically they are common in government papers because probably cheap. Ne? So we will use the requirement is to have a public notice. So government papers I think are cheaper. Therefore you can read those papers, probably you never will read those papers. But even they may be available in other papers as well. So anyway, there are public notice about the reduction of the stated capital. If you read the 2-3 papers, you definitely see it. Right? And you may find some other public notice related to company, maybe change of company name, right? Maybe reduction of the stated capital, maybe notice about the company meetings, maybe notice about the winding up of companies, right? Whenever you have the paper online or hard copy, just look whether you could find it, right? And you used to give some continuous assessment as well, but for now new generation I don't do. This one among confusing the collect the booklet a public notice. So from the incorporation up to the winding up, there are so many requirements of public notice. Right? Then they know that what they learn is in fact happens. Right. So 60 days before passing resolution, public notice should be given. You can read those notice on public or national page. Right. Then some companies may have entered to agreement with banks, as I said before, that they will not reduce the stated capital less than a specific amount. Because when banks give loans to the companies, they enter the agreement with the company that they will not reduce the stated capital less than that. Probably at least about 90% of the loan amount. Then, when there is such an agreement with the bank or any other financial institution, even though company follow the procedure and reduce the stated capital, first reduction is invalid. Right? Whenever there is such agreement, company cannot reduce the stated capital, even passing is special resolution. If they have done, it is invalid and no effect. Right? Then, if there is no such agreement, by passing resolution, giving notice, public notice, 6 days before the passing of resolution, then they can reduce the stated capital. Once the stated capital is reduced, then within 10 working days, registrar general should be noticed with the previous stated capital reduction and the new stated capital. So that is the procedure to reduce the stated capital. Right. So just let me know why companies have to reduce the stated capital. Because it's not a good practice at all. Only permitted when it is not. There may be some reasonable reason for the companies to reduce the stated capital. Can I explain to you? If you can look at it, the company has to do the job. So they have to do it. Even though it affected the capital, they have to do it. So redemption and refinancing. 2 occasions where companies have to give, even though it's affected or not, they have to do it. So apart from that, we have done another thing minutes before. Diploma, they are maybe some companies, they have a profit. Right? They have profit, then if they have profit, what they can do? They can pay bill. But before paying bill, what they have to do? They have to satisfy the solvency. Right? But the stated capital is too high. Right? Then can they pay this dividend? As an example, we can see here, we have assets of 100 million, right? So it has to be greater than the liabilities and the stated capital, right? So stated capital is, let's say, 90 billion, right? And the liabilities is 20 billion. Now, can this company pay dividends? They have profit. Can they pay dividend? No. What is the reduce the stated capital to 7? Yes. Now data. Okay. So that's another reason some companies have to reduce the stated capital, right? To take the payment of dividends, some companies have to reduce the stated capital. Otherwise, companies cannot satisfy the solvency. But they haven't done the soft for the because maybe they have to do it for the before distributed. Because after any distribution or dividend, the companies have to satisfy the source requirement. Right? Therefore, by reducing the state capital, then they can make it effective. Right? So that's another reason. So what else they can do? What are the other reasons that companies have to reduce the state capital? Actually, there's a huge state capital. Even though they have profit for years and years and years, they cannot get it. From the beginning, I think it's for 1 year, 2 years, it is not profitable. But if they make profit for 5 years, but still they have a huge scale. They never will be able to get it. Then they can reduce the scale. Some of the state coverage advantage. So redemption, return, payment of distribution or dividend. Check just let me know some of the reasons. Why companies have to demonstrate payment. When there's an evaluation week, I was also a member of the evaluation week. So there's a parliament committee asset. There's some parliament evaluation, right? Kabir, I think is the president of the international parliament group for evaluation. Yes, they will know. So if people listen to everything, so professionally, the promise that under his government, they will make the evaluation and monitoring part of government policy. So if you use parliament to get into the government, that's what we can do. Parliament government use the same. So Parliament government you out of the lady in the man again, because the name knowing the bill is being drafted and finally accepted. But they were passed. Means this is official. They go to make up of the start on a gas demand. And you project management officially get the also came on the monitoring majority I'm done. But what are the other reasons? Today we just give it that. To simplify the capital structure of the company, companies can reduce the state of capital. That's another reason to reduce the state of capital. There will be so many different types of capital. To simplify them, they can reduce it. Okay. Another reason. Actually, there's a surplus. So, yes. So, if there's a huge capital, so they can return some of the surplus to the shareholder. So, to get the benefit, return some surplus to the shareholder. Okay, good. So, we can reduce that to the holding shareholder. So now we are at it, right? There comes concept of reduction of payment commission. So you can say repurchase, redemption, or to make dividend, to make distribution. To simplify the capital structure of the company, to return the surplus to the members, if there's a transfer of assets that may be the state of that. If there's a transferring of assets, okay. Right. One thing is to simplify the capital structure, and two, make the capital structure more efficient. But that's the whole first. Now the reason is to make efficient capital structure to more efficient. Correct. But yes. What will happen to the liability of shareholder when capital is established? Increase or decrease? So that's the increase, right? Sometimes reduce the stated capital to reduce the liability of shareholder. If there's a 1 million, they are liable for 1 million. If there's a 10,000, they are liable for 10,000. So to reduce the liability of shareholder. Any other reasons? Oh, yes. If you do your compare work, just you can ask what the reason to this state of capital, right? Because when you go to the papers, you will see there are at least 2-3 public notice on papers almost every day about the reduction of the state of capital. So they do for some reason. That is right. So now we know at least there are some reasons for the compliance to reduce the state of capital. So that is why the law permit, right? That is why you don't need to go to the court, because there are enough reasonable reasons for the compliance to reduce the state of capital. Then it's a business, you don't need to go for a lengthy process, but you can do it within the company, but only according to the proper procedure. The section 59 says the 75% of shareholders must agree. The public should be aware of that. Therefore, public knowledge should be given. If there's any contract with the outsider, then you can do it, even though you do it if there's no effect. Right? So if there's no such agreement, then the company can do it. However, after reducing the stated capital, again, it's the duty of the company to notify the registrar general within 10 days about the reduction previous stated capital and the current previous stated capital. So that's a procedure to reduce the stated capital. What's the time now, Raman? Repurchase of shares. So, there is a special section for the repurchase of shares because when company repurchase external shares, what will happen? When they buy this, they are on money. Therefore, that definitely will affect the statement of that will reduce the statement. Therefore, there's a proper procedure again that the company have to pass. But sometimes company has to do it. So when there is such a requirement, company can repurchase external shares, but again according to section 66. So read the section 66 and how company can repurchase external shares. There are three ways where the company can repurchase its own share. The first one is if the articles of the company provide. If the articles of association provide for it, then the company can do. So if it's done for some reason, at least the contract, so the shareholders are bound by the fund. So that's the one way. However, even if the article provide for that, then the board has to satisfy the solvency test. Immediately after the repurchase of the shares, company will not carry. And then another way is that if the company is a private limited company, then with the agreement of all the shareholders, they can do. Private company, you know, it's a business between kinship and friendship. It does not affect the society of company. Therefore, in a private company, the members can do it, provided that all the members have a green time, all the shareholders, 100%. So, there's no such event, but still the company want to repurchase its own shares, then they can apply the court. If the court made the order, with that court order, company can repurchase its own. So that's the way to repurchase its own shares. So all those strict rules are there because it affects the stated capital of the company. That can be there is the repurchase of shares. Someone give us how to not tell us never. Right. Redemption of shares. Redemption can only be done if the article provides for it. Otherwise, company cannot redeem the issued redeemable shares. The share is redeemable if the articles of the company make provision for the redemption of that share by the company at the option of the company, that will be at the option of the company, or at the option of the owner of the share, or on the date specified in the articles of association. Okay, to discuss about the debentures. You only wrote about the share, the other part of the company is the debenture. Right? First, the other way around. Right. So, what are the difference between the debentures and shares? Are they same or different? Different. You all know debentures are shares are also there are different type of shares. So as debentures also there are different type of shares, right? So you will learn that, right? So maybe renewable debentures, it is renewable, convertible, non-convertible, part convertible, fully convertible. So there are different type of debentures. Right? Because some debentures one should they can be transferred to shares at all. There are some debentures they can be yes 50% maybe share, 50% maybe you have to maybe like that there are different types of share debentures. So as you all earlier and agree, even low believe that the shares and debentures are two different types of things. Right? But this is mainly because of legal, historical, and traditional things. But if you look at the current situation of debenture and the different types of shares, sometimes for the new people probably you can understand. But for the general layman, hopefully, they don't know difference between the shares and debentures. So we all know that these are two different things. So what are the differences between shares and debentures as you know? Debenture holders are creditor. Shareholders are owners. Okay, what else?
At a winding up, they prefer. At a winding up, they prefer.
Yes, at the winding up, creditors will get priority. Shareholders have no such priority. Okay. The debenture holders are entitled for the interest, whereas shareholders are entitled for the dividend. Okay. Yes, debenture holders, they have interest, they don't have voting rights, they cannot come in the meeting and so on. So, but shareholders, they have a right to attend the notice, vote, and get it. Yes, the debenture holders are entitled for the fixed interest, their debenture holders are, so their holders are dividend that they have. Yeah. So because of those reasons, it is true to say that debenture holders and shareholders are two different parts. And also shareholders sometimes they can be directors and so on and so on. The debenture holders they don't take those things. Right? However, at the same time now we know that companies can issue different type of shares and also companies can issue different type of debenture. Now, if I ask you to compare the ordinary shares and the preferred shares and the debenture, what do you see? What similarities can you see or what differences can you see? Yes.
They are the profit, but debenture holder may get the return even though they are.
But okay. Yes. It's still that dividend and interest is applicable. Right? However, both are entitled for the fixed amount. Okay. Both are entitled for the fixed amount and both will get preference of priority over ordinary share. Probably both have no voting rights. Because shareholders and people both have no voting rights. Companies also issue preference shares or shares or debentures agree for the same reason. Right? Capital issue shares or debentures to raise the capitalist capital. Same reason. I hope even for the investors, general public, it is just a method of investment. I don't think when they buy shares or debentures in the public domain, they will think whether they are owners or creditors. Would be a real thing, or whether it's just a method of investment. For many, at least, it's just a method of investment. Therefore, right, so companies issue those both for the same reason. The general public buy both for the same reason. So both have no voting rights. Both are entitled for the fixed amount. Both will get priority at the winding up. Even when you do accounting and audit and whatever, coherent the cut done. That is the assessor model done. Only shareholders side, creditors side and investors. Oh. Sorry. Preference shareholders are there, debentures are there, holders shareholders are there. Account. Understanding with the but I know that, yes, preferred shareholders are grouped with the debenture holders, right? Not with the ordinary shareholders, right? The one on the payment, and I find that. They only can be with the ordinary shareholders if there's no liability at all. But almost all the preferred shareholders have some type of liability. Therefore, they group with the debenture holders. They will not take it. Therefore, by today, it has become such a gray area, such a blurred area. The difference between these two. Probably we can discuss in the classroom because so and so near the division, but for the general public, I don't think they really have such a matters, and probably they don't care and they don't know whether I'm a debenture holder or creditor or they are holder or whatever, right? It has become such a gray area because of those different type of shares that we will have the issue. Right? Sometimes some people even cannot understand it. Right? So I only discuss about the different shares and the debentures. You can see. Even you are in doubt now, right? But I'm not very good. Sometimes some people get advantage. Right? Say as an example, because of the traditional knowledge, traditionally, historically, legally, they are two different things true. But practically, it's a gray area. Right? Because of that traditional knowledge, someone like BOC has taken the maximum advantage. Right? What will happen if BOC issues shares? At least they will try. But only few knows in this country that they have issued the dividend. Right? Somehow done this now, we also give it to people. Right? So it's the traditional knowledge. Right? If issue shares, then ownership is diluted and so on. So when you should depend the people don't think that those type of things is the difference. Therefore, they have taken that advantage and they have issued debentures. No one question. But if they issue shares, hopefully they are in this so many. Right? Well, that is done. Get on with content of Halil that party. Fit there than a guarantee company, so I can them a private sector. Person minimize until they are there. BUC issue the debentures, shares issue the never do that. But almost no difference. The debenture holder by factor of the power than a group that comes up. So therefore, if you know those two aspects of everything, sometimes you can get advantage, especially when you face the general fund. However, you are correct, as I told you before. For legal reasons, concern historical reasons, people still believe they are two different things. But honestly, today, it has become such a area. Sometimes you can't even think whether they are creditors or owners because of such a big stuff in the different type of share. Okay, then. But so that's why this was so done. So, and then we continue from next Tuesday. So next Saturday, next Saturday we can also do that because we have to do something for the 10 things that we do. Okay. So we try to discuss the legal aspect of shares, debentures, and capital today, right? And also the importance of maintaining the capital of the company. So out of the important thing for the exam, like you need to have you should be able to get the solvent test done. If the question, if you get a market that I have given some help to make the solvent test. You should be able to get it done. And also how to reduce the stated capital and what are the reasons for the company to reduce the stated capital and what are the importance of maintaining the capital of the capital. So you can do this lesson next week as well. So with that, we will also have online feedback. So what we will